Yo, it's JP. Let's talk about retaliation. Okay, great topic. Let's start here. In America today, 2025, retaliation is incredibly common. And it is far more common than corporate America, big law, the judiciary. It is far more common than any of these folks would have you believe. And that makes sense because America has reached a point where big companies have so much power. They have incommensurate, unchecked, absolute power. And you see this propped up, right? You see this propped up by all sorts of elements and aspects of society, and particularly propped up by the American legal system, which is not a justice system. It is a legal system built, bought, and paid for by powerful interests and folks with a lot of money. What's a great example of this? Arbitration, okay? Arbitration started, 100 years ago as a tool for sophisticated parties, basically big business person, to avoid the litigation process and then go resolve their disputes via a different mechanism, via arbitration. It was basically a business to business, sophisticated actors sort of situation, right? Fast forward, right? Now, everybody has arbitration. You go to somebody's website, you go to a company's website, you click through something, oh, you have arbitration. Even if there's no proof that you clicked through it, the company just goes to court and says, well, we have this arbitration agreement on their website, so they must have signed it, Your Honor. And the judge says, I agree, there's a strong federal policy in favor of arbitration. Go to arbitration. Was that ever what arbitration was intended to be when it was originated? No, of course not. But corporate America will use, abuse, lie, cheat, steal, manipulate, and leverage whatever they can leverage to get more power and to get more immunity from ever being held accountable. That's a great example right there. Arbitration. That issue right there alone, arbitration agreements alone, have done so much in America to prop up corporate America and protect them from ever being held accountable. Same thing with jury trial waivers. Same thing with judicial activist judges rubber stamping bogus non-compete agreements for employees. Same thing with judicial activist judges making it impossible for employees to survive summary judgment in a discrimination case. All of this stuff goes the same way, okay? All of this stuff goes the same direction towards making corporate bad actors in America untouchable. And yes, of course, there are some times when you do actually get a clean shot at them. You can hold them accountable, right? All the stars align and it's great. And there is an outcome that is truly just and fair and good, right? But those are few and far between. For the most part, corporate America is untouchable. And they built this whole system this way, okay? All their cronies, all their allies, all their money, all their lobbyists, all their judges, right? They've got all of it set up, right, to operate in their favor. And so it follows from there that, of course, companies are going to retaliate. Of course, they're going to retaliate, and they're going to do it with absolute impunity. They're going to do it every single day. So rather than the norm or the dominant paradigm being something reasonable, fair, with integrity, things working and functioning the correct way, American business and commerce now functions in this totally perverse, bizarro universe, Voldemort sort of way, right? Like all these people running around like Skeletor, Voldemort, Mumra, right? But like, that's who these people are, and that's how they get down. And so, of course, they're going to retaliate, okay? So let's talk about retaliation. Basically, anytime you express concerns about your rights in the workplace, anytime you ask a question about Are you being paid appropriately for working overtime hours? Or are you entitled to overtime pay? Shouldn't you be receiving overtime? Should you be getting time and a half? Or you ask a question about your particular salary or wage as a woman when you have the same job and you trained this man who has much less experience than you, and you're making $26 an hour, and this man you just trained who has less experience is making $28 an hour. You've been at the company longer, and you actually hold this role and additional responsibilities, and you do more work than he does. You ask that question, okay? Or you have been repeatedly passed over for a promotion, and you've been told that you just don't have the right fit to be management or a supervisor at the company. You just don't have what we're looking for. You're just not a good fit for that, right? And you wonder why. And it turns out that less qualified people than you have been promoted into those positions. And what's the difference? Well, you happen to be a black person, okay? Right? And so you ask a question about this and say, is it possible that I'm, being discriminated against unfairly on account of my race? As soon as you raise any of these issues, there is probably an 80% or better chance that you are going to be retaliated against in some way, shape, or form. So what can you do, right? What do these situations look like, and what can you do, all right? Number one, there is very strong law against retaliation. Whether or not the courts apply it correctly at the trial court level, in the federal district courts, different question, different story. But the law as written and coming out of the appellate courts is extremely favorable for plaintiffs in retaliation cases. And I often tell folks that it is easier to prove unlawful retaliation than it is to prove the underlying misconduct. So for instance, let's say it's a discrimination case, all right? Somebody raises concerns about unlawful discrimination, age discrimination, sex discrimination, race discrimination. They raise the concern. Regardless of whether or not there really was discrimination, regardless of whether or not they could actually prove discrimination, the retaliation claim exists completely separate and apart from that. There are plenty of cases out there where somebody fails to prove that there was unlawful discrimination taking place, but they still successfully prevail on the retaliation claim because these claims involve different elements, okay? If you're trying to prove, for instance, unlawful discrimination, okay, then you need to be able to check those boxes. You need to be able to show that you were treated differently on account of race, religion, age, etc., right? But when it comes to retaliation, your retaliation claim exists separate and apart from that. It doesn't matter at the end of the day whether or not you succeed in proving the underlying discrimination or other misconduct. You can still prove that you raised certain concerns, you spoke up about your rights, and in response to that, the company retaliated. And that is why in many instances, the stronger of these claims, okay, in cases like this, you'll often see a discrimination claim, unpaid wage claim, whatever it is, and then you'll see a retaliation claim. And in many of these cases, the stronger claim is a claim for retaliation. So if you are going to speak up about your rights, if you're going to speak up about possible discrimination, unpaid wages, unpaid overtime, unequal pay, pay disparity, whatever it is, if you're going to speak up, you got to do the following things. Number one, it has to be in writing, okay? I've said that before. I'm going to say that again 600 times because every single day our firm hears from folks who voiced concerns or made a complaint, and they only did it verbally. They only did it in a meeting, person to person, or they did it on a phone call. What does corporate America do? Okay? Corporate America is exactly who I say they are. They are exactly what you think they are. They are what we know they are, right? It's like that football coach. They are who we thought they were. And we let them off the hook, right? Don't let them off the hook. Don't let them off the hook, okay? Put it in writing. Put it in writing, okay? And I know that a lot of people think, well, I want to be, delicate about it, and I don't want to trample on any toes. And so the best way to do this is probably just kind of informally, have a casual conversation about it. Nope. And I'll tell you why, okay? One, corporate America is going to pretend like it never happened. If it's not in writing and there's not a paper trail, it never happened. I cannot begin to count the number of times that I have seen corporate bad actors, HR, management, etc., lie through their teeth and deny that a person ever complained or raised any concern. Right? He never said it. He never said anything. He never said anything at all. Right? Yeah, he had great reviews, and then his performance just fell off, and he became a terrible employee, and we had to fire him. But he certainly never said anything about discrimination or any unlawful treatment. And then finally, if it exists, you find, right, the smoking gun where it's like it was in writing and there's text messages flying around about it. And then all of a sudden they're like, well, we must have just, we forgot. We didn't know. Companies do that all the time, right? Like if a regular person, so a working person, poor person, were to go into court and lie, federal judge is going to be like, this is a federal court. I am a federal judge. I'm appointed by the president, and you lied to me under oath, and this is perjury, and there will be hell to pay. But when a company lies, company just says, well, Your Honor, we're so big. My goodness, we're just such a big company. We can't keep track of these things. And courts are basically like, well, it happens. It happens. I understand. No harm, no foul, right? Different rules for thee and me. Okay, that is how the American legal system really gets down. All right. And everybody who knows that is the real. OK, so you put it in writing, and not only do you put it in writing, but you be explicit about it. You be direct about it. That doesn't mean that you pound the table and scream and yell and you're over the top and hysterical. No, that means you are direct, to the point, and you leave no room for any confusion or misunderstanding. If you believe that you are being retaliated against, right? Like if you believe that your rights are being violated in any way, shape, or form, you put it in writing. You put it in writing. So if it's discrimination, you put it in writing. You say, I believe I'm being discriminated against on account of X, Y, Z. Okay? You paper it up because you need that trail. You need that paper trail. You need that documentation. You need that evidence. Okay? Because the retaliation is almost certainly going to begin right after that, okay? And you continue to paper it up, okay? You make the original complaint about discrimination, misconduct, whatever it is, whistleblower situation where the company is engaged in illegal activity and you're being pressured to engage in that illegal activity too and just turn a blind eye. You paper it up. You paper it up and you keep papering it up. And when the retaliation starts, you paper that up, okay? And you want a trail going from when the original misconduct started, the original violation of your rights started, and now I'm being retaliated against, and here's the following instances where I'm being retaliated against, right? You just be matter of fact. You don't have to be over the top. You don't have to be dramatic, but you got to be to the point, direct, matter of fact, and you continue papering it up, all right? Now, a lot of companies will basically approach these situations with the following goal. Okay, they are going to make your life so miserable that you just quit. That's what they're going to do. All right. You complain about discrimination, whistleblower, what have you. You get retaliated against. You complain about that. You document that. At this point, the company's basically like, we are going to make his life or her life a living hell. We are going to make them so miserable. We are going to reassign them. We are going to make them have unfavorable working conditions. We're going to take the door off their office. I've seen that. We're going to send them across town, to a less favorable location. We're going to give them a less favorable role. We're going to give them 16 more responsibilities and completely overwhelm them. I've seen that. Okay. I've seen situations where a salesperson complains about sex discrimination, unequal pay, unequal compensation, unequal resources for their sales team, unequal support staff versus men and women. And the company doubles her quota overnight, effectively. Here's the complaint about the sex discrimination. Within a month or two later, you get double quota. And now the company says, yeah, she used to be a star performer. She was hitting 92% of her targets, and then her performance fell off dramatically. And so, she put on a performance improvement plan. We give her a bunch of warnings, got to get her act together, right? Like, companies do this all the time. And sometimes they'll fire you, okay? Other times, they're not going to fire you, but they're just going to keep pushing you in that direction. They're going to keep pushing you towards either them being able to fire you and plausibly deny that it was discrimination or retaliation, or you just having enough and voluntarily resigning. And so a lot of folks reach out and they want to know, right? Like, should they stay? They say, well, should I stay and just wait till I get fired because then maybe I'll have a stronger case? I hear that all the time. And I understand that a lot of other lawyers literally tell people, yep, you got to stay. You got to stay until they fire you. And that's going to set up a better case for you. You cannot live your life. You cannot do your day-to-day existence on this earth scheming out some theoretical lawsuit that you're trying to set up at the advice of some probably not very good lawyer. Okay? That's the reality. That's not a legal question. It's a life question, right? Like, should you stay in an environment like that and continue to tolerate it? And now this gets into all sorts of problems in the law and in terms of the way the law is applied. Okay, for many years, courts, judicial activism, making up court-made law, right? Not following Rule 56 and the various statutes and laws that are applicable, just courts making stuff up and effectively saying, well, in order for there to be a claim here, the company has to fire you or do something like that really materially screws up your job, right? Like, it has to be really, really bad to a level that we think is preposterous in order for us to say there's actual retaliation there. That's nonsense. That is nonsense. There is no condition in the actual statutes or the actual law, not federal district court, trial court made law, but actual law, not judicial activism law, but actual law. There was no requirement there that you be, for instance, fired in order to have a retaliation claim, okay? Retaliation can take many different forms. If you're reassigned to a less favorable territory, if you're given a quota that is double what your prior quota was, if your hours are cut, right? It can be any number of different things. If a company is taking actions against you in response to you speaking up about your rights or speaking up about certain workplace or corporate misconduct, if you can tangibly point to something and say, this is what they're doing to retaliate against me, then you have a retaliation claim. Sometimes those retaliation claims and sometimes the nature of the retaliation does translate directly into lost income, lost wages, lost dollars. But here's where corporate America gets cooked all the time, okay? The relevant statutes, the relevant laws, whether it's Title VII, whether it's in Florida, the FCRA, whether it's 42 USC 1981, which governs race discrimination, the relevant laws here provide for more than just lost wages or out-of-pocket damages. The relevant laws here frequently provide for at least some compensatory damages, sometimes unlimited compensatory damages, and in certain instances, they provide for punitives and even unlimited punitive damages. So the notion that a retaliation claim isn't real unless it is directly traceable to XYZ significant loss dollars out of pocket in terms of wages, salary, or income, that is nonsense. Retaliation is retaliation is retaliation, and it is unlawful. So you have to document it. You have to document it the whole way. There's a very good chance that the company is going to try and push you towards the door. They're either going to push you out of it or they're going to push you right to the brink. And at that point, you have to make the decision about whether you stay and deal with that sort of treatment, you deal with that sort of day-to-day existence, or whether you leave. I know everybody has to make a living, everybody has to pay the bills, but personally, I'm not taking that shit, okay? I'm out the door. And just because you voluntarily leave, just because you resign, just because you quit, doesn't mean that you don't have a real case. There are a lot of attorneys who tell clients, they tell employees, well, if you quit, you just don't have a claim. And that is simply not the truth. We have pursued a number of cases where our client voluntarily resigned. Our client voluntarily quit, they weren't fired, and we still went after the company and ultimately prevailed. So you either stay until they fire you or you resign, you leave of your own volition. Either way, you file a charge of discrimination with the EEOC. And in fact, if you're going to stay, there's nothing to stop you from filing a charge of discrimination with the EEOC while you're still working at the company. Okay? Yeah, it's going to be more contentious and they're going to constantly be on your ass. Absolutely. And also a firm like ours, I'm not getting involved. I'm not touching the case when a person still works at the company. Okay? I've seen that before. I've done that before. And what happens is they expect me to play the middleman, right? They expect me to route messages back and forth. I'm the go-between between the company and the employee while they're still working there on a day-to-day basis. That's completely unworkable, okay? I'm not getting involved with that. It's not my job to play nursemaid to the world, okay? You wanna quit? You wanna step up and be like, you know what? My rights were violated. I'm not tolerating this. I am gone. Goodbye. Sayonara. See you, okay? That's different. Then you can reach out and then we'll put the case in the process. But either way, you go to the EEOC, you file an EEOC complaint. And when you file an EEOC complaint, okay, remember this, all right? EEOC complaints were never supposed to be this technical game of gotcha, okay? They were never supposed to be magic words or technical traps or gotchas or what have you. And yet certain states in the old Confederate South have decided that you need to say magic words and that there are all these gotcha traps. And if you don't say the magic words, you lose a bunch of your claims. That's absolutely nonsense and completely counter to the whole purpose of civil rights laws, okay? But this is America after all, okay? And so whatever benefits, whatever advantages the power structure can give to corporate America, they're going to give to corporate America. And so you have to button it up, which means when you file your EEOC charge, you have to check the box for discrimination, retaliation, and other, all right? Very important point. Check discrimination, check retaliation, and check other, because companies, look, these people are too clever by half. It's absurd. It really is absurd, and the emperor has no clothes. And that's why I'm telling you this, okay? I have seen cases where somebody checked discrimination, but they didn't check retaliation. And then in their narrative or in their allegations, they clearly discuss retaliation. And then the company turns around and says, well, they didn't check the box for retaliation, so they waived the retaliation claim because they didn't check it. We weren't on notice. We're a big, sophisticated company. We're represented by a huge law firm. We've done lots of these cases. We've been sued 1 million times. But because they did not check the little box that says retaliation, we had no way of knowing this was a retaliation claim. And so it should be dismissed. Companies and their lawyers make this sort of argument all the time. They make this sort of argument all the time. You know what the thing is? Like, I would be ashamed, okay? I would be ashamed if that was my livelihood. I would be ashamed if that was the work that I did, right? Was trying to find these squirrely technical gotcha arguments that are so bad faith and immoral but advancing those to try and serve my corporate overlords. I would be disgusted with myself. I couldn't look myself in the mirror at night, and I would not sleep soundly. Thankfully, I'm none of those things, and I sleep very well. Thank you. But you have to check all those boxes, okay? Less corporate America say they didn't get appropriate notice, and then some court believe them and say, yeah, they didn't get appropriate notice. We got to be protecting these companies out here from a retaliation case that they couldn't have possibly ever imagined, even though it talks all about retaliation, okay? That's real. The emperor has no clothes, okay? In addition to checking all the boxes, you have to make sure that you identify whatever particular statutes or laws you plan to proceed under, and you identify those in the body of your EEOC charge, all right? And then from there, you just either have to find an attorney who is willing to pursue your case, file a lawsuit in court, litigate the case, or, worst case scenario, you got to file it yourself. But if you speak up about your rights, you have to expect in America 2025, you are going to be retaliated against. Document it. Don't soft shoe it. Document it. Be direct. Be explicit. If you're being discriminated against, your rights are being violated, you're a whistleblower, what have you, put it in writing, put it in email, make sure you retain a copy of it. When the retaliation starts, document. They're going to push you toward the door or out the door. I say walk out the door voluntarily, file a charge of discrimination with the EEOC, sue these people, and go for it with gusto, because that is the only way that society is ever going to change, and that's the only way we're ever going to hold corporate bad actors in America accountable. Thanks for watching. Happy Friday.